have concerned the rights of criminals and those accused of crimes. During the 1950s and 60s, the court interpreted the Due Process Clause of the 14th Amendment to mean that law enforcement and judicial procedure as defined in the Bill of Rights were uniformly applicable in the state courts as well as in federal.
The first 10 amendments do contain a number of very specific rights applicable to criminal law enforcement. There is the Fourth Amendment right against unreasonable searches and seizures. There is the right to counsel. There is the right against self-incrimination. There's a right to have witnesses, the right to confront the charges, the right to notice, the right to hearing. What has taken place, broadly viewed with considerable controversy, is a nationalization through the Due Process Clause of fair law enforcement standard practices. Gideon and Wainwright is a significant case of saying in 1964 that everyone is entitled to be represented by counsel at trial, and if he can't afford one, he must be appointed by the court and paid for by the state.
In the Miranda case, the court went even further and laid out specific guidelines for a police officer to follow, and now the police officers have printed cards in which they ask certain specific questions in order they should comply with the Miranda decision. Before a defendant is questioned after he's arrested, he's advised that he doesn't have to make a statement, that if he makes a statement, it may be used against him in the trial of a criminal case, that he's entitled to counsel, and that if he hasn't enough money to secure counsel, the police officers will make a telephone call and see that he gets an attorney before he makes the statement.
The basic rights of ordinary citizens, the rights to free speech, free assembly, free press, free association, freedom of religion, are covered in the First Amendment to the Constitution.
Congress shall make no law abridging the freedom of speech. As an example of the difficulties lurking even beneath the simple provisions of the Constitution, those few words have, in the 50 or so years that the court has dealt with them intensively, have given rise to a great deal of controversy. Why is that so? Well, despite the absolute sound of it, virtually no one on the court has ever really thought that you could say all speech-related activities are immune.
When speech incites others to criminal acts or acts of violence, then the freedom to speak out may legally be sharply curtailed. Freedom of speech is closely associated with freedom to assemble, but the Constitution says, quite specifically, that the right of the people is peaceably to assemble. The guarantee of freedom of religion has stirred up the biggest storm when it has come to the question of religion in the schools.
23rd song.
The Constitution has two separate related guarantees. One guarantees the free exercise of religion. The other one is a clause that bans the establishment of religion. What it has meant is a scrutiny by the court of various state involvements with religion, with prayer, with religious education, with religious exercises, to make sure that the state and religion don't get too closely intermeshed.
Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil.
The state of New York drafted an official prayer, a very lukewarm, kind of vacuous prayer, to infuse some religious ideas into the public schools. The court invalidated it on the ground that this was too much governmental involvement in religion.